Ralph and Ralph.
Yes. Yes, Mr. Dutton.
May it please your lordships, I appear on behalf of the appellant, together with Mr. Woodhead, and my learned friends Mr. Green and Mr. Calzavaro appear on behalf of the respondent. My lords, this appeal is of course concerned with the circumstances, or perhaps rather the test, that applies, determines when a court can rectify a TR1 on the grounds of mistake.
Well, I just wonder if that's what it really is about, Mr. Darton. The problem here is that the TR1 is signed only by the transferors. And it says in the notes to the current edition of TR1 that the transferees must sign if there is a declaration of trust in box 10, now it used to be box 11. So in this case, the transferees, namely Mr. and Mr. Ralph, did not sign, and that is therefore not a valid declaration of trust prima facie under section 53(1)(b) of the Law of Property Act. So this may not really be about rectification at all. This may be because there is no valid declaration of trust, subject to something that may be said in Stack and Dowden by Lady Hale. So the question may only be your ground 6, which is the Stack and Dowden exercise undertaken, if it was undertaken by Mr. Justice Morris.
I'm grateful, my lord, although obviously surprised, no doubt wrongly, but grateful. Can I indicate this? I would wish to, with regard to the version of the TR1, I haven't checked that point, I'm sure your lordship is right.
Have we got the notes on the TR1? We haven't got it in the core bundle.
My lord, as I understand it, and I'm afraid I'm not fully prepared to address your lordship on this very salient point, but as I understand it, the TR1 has changed in format in recent years.
Right.
So I only pause there to say that whilst your lordship's observations are no doubt right as to the present version, I don't necessarily, in fact, I wouldn't at this stage wish to concede that it is right.
No, of course you wouldn't. I mean, section 53(1)(b) hasn't changed. Section 53(1)(b) is quite nearly 100 years old. And it provides, just in case you don't have it immediately in your head, it provides that subject to the provision hereinafter contained with respect to the creation of interests in land by parole, a disposition of an equitable interest, a declaration of trust respecting any land or any interest must be manifested and proved by some writing signed by some person who is able to declare such trust, or by his will. I don't see how a transferor can declare a trust of the transferee's property.
This point is addressed in the judgment of His Honour Judge Monty, Queen's Counsel,
right,
in relation to a more recent case of, I think it's His Honour Judge Matthews. But as I recall matters, it goes back to Re Gorman, where it was held that the absence of signatures by the transferees did not alter the effect of the declaration.
Right. We'll have to look at that. Anyway,
so
you must take your own course, but that's what's concerning me at the moment.
I'm grateful. Well, my lord, perhaps let me set out just very briefly where this appeal was before your lordship's helpful observation was intended to go. And perhaps I will be therefore concentrating on what will be part 1 and I think perhaps part 5 of it. The way this appeal came before this court was essentially following the following steps. The first is that the TR1, where it declares the beneficial interest, is definitive. And I, of course, note your lordship's observations on that. And we've cited 3 cases with regard to that: Goodman and Gallant, and I think the reference there was 117C to E, with the judgment of Lord Justice Slade. And then Stacking Dowden itself, paragraph 49, Lady Hale. And then more recently, Pankania and Chandigarh, which was 2013, paragraph 17, which is Lord Justice Patton, and paragraph 27, Lord Justice Mummery. Now, in each of those cases, the court has found that the declaration excludes consideration of constructive trust. And thus the only way to get around that declaration is pursuant to mistake or rectification. Now, it may be if your lordships are good enough to grant me the indulgence, I shall address Re Gorman and those other cases where I say this question of the lack of signature has been addressed. But what I would wish to do before I go to that, since I have it to hand, is could I take you please to tab 7 of the bundle of the authorities, which is the speech of Lady Hale in Stacking Dowden.
Yes.
Because as I know your lordships will be familiar with this, there, at really going on from, so it's page 458, going on from letter C down to H.
Sorry, which in the you don't know in the electronic bundle?
I'm sorry, my lord, no, but it's tab 7, and it will be about halfway through, page 458, I'm afraid, on the law report.
Okay.
108.
Thank you. Yep. Got it.
And there, Lady Hale not only sets out the rule as we contend applies both to circumstances when the TR1 is signed and unsigned by the transferee.
So which paragraph are you reading from Lady
I'm
Hale?
sorry, my lord. It would be paragraph 66, but if you go from page 458, letter C, my lord, I contend if you then follow that down to H, you will see a summary of what I would refer to as the public policy reasons for the rule that the express declaration determines the party's beneficial interests, and the dicta for which Stacking Dowden is now famous, that in fact there is a presumption that the beneficial interest follows the legal interest. So Lady Hale, in my respectful submission, allies the two, and she sets out there, I would contend, some very powerful reasons as to why the law should be as we contend it is.
Which is what?
Which, my lord, if I could summarise it in this way, is firstly that it isn't in fact based...
So what's the proposition of law that you are advancing by reference to paragraph 66 of Lady Hale?
The proposition of law I'm advancing, my lord, is that there is authority, that whether the transfer document is signed by the transferees or not, it still gives rise to a binding trust. It is still a contract. Because, my lords, of course it is a contract. The TR1 may contain a declaration, but it's also a contractual document.
So it's a contract and a binding trust, whether signed by the transferees or not. That's your proposition.
Yes,
now just show me where Lady Hale says that, please.
Well, my lord, she doesn't expressly address that, and that is why I'm taking you to the parts where I have the authorities before me.
What was the facts in Stacking Dowden?
Well, Stacking Dowden, of course, my lord, is a different case. It's not concerned with an express declaration. But the reason I take you to these passages is to point out, if I may, that there are very firm public policy reasons behind the law being as we contend it is.
Okay.
One of which is certainty. The second of which is, of course, there are third-party interests engaged with regard to a TR1. As your lordships will, of course, know, the TR1 is readily available, and on the face of it, it defines the parties' beneficial interests. Now, of course, previous case law establishes that that declaration could be rescinded for mistake or it could be rectified for mistake, but only in very limited circumstances. If the law is, as the respondents contend, then the reliance which third parties can place upon a TR1 is very limited.
What do the respondents contend that makes that the case?
Well, the respondents contend, my lord, in effect, that the TR1 is only of evidential value, that as long as the court is satisfied after an inquiry that the declaration in the TR1 did not reflect the party's actual intentions, then, in the words of His Honour Judge Monty, Queen's Counsel, it can't stand.
But third parties are always going to be prejudiced in relying on a TR1 if the ingredients of rectification are made out. It's not
of course, yes, of course they are, my lord. But it's the question, it is whether it is rare or commonplace. What I'm submitting is, when you read those paragraphs from the speech of Lady Hale, as you've been good enough to do, you will see there the clear identification of the problems you have with ownership of property, which is that the parties to a transfer don't necessarily understand what they're entering into. That's the empirical evidence that's referred to in this speech. Secondly, there are the interests of the lenders. Thirdly, there is the inevitable temptation that the parties will, many years later, misremember or reinterpret, I think was the word that Lady Hale used, the facts surrounding their transaction.
I mean, what bothers me, you know, I understand, Mr. Darden, all you're saying about what Lady Hale was saying, but the facts here are not established. We don't know who put the cross in the box. We don't know if it was people acting on behalf of the Ralphs or just the transferor. We don't know. Could be anything. Could be anybody. We don't know if the TR1 was ever even shown to the Ralphs or they ever gave any instructions about it. But none of that matters, you say.
Well, my lord, to the contrary, I say those very difficulties that your lordship has so properly highlighted go to show the danger of going down the route that was pursued by the learned trial judge. There was no conveyancing file.
No conveyancing file, no.
This was a transaction which happened some 20 years ago. The judge made findings of fact, against which I can't appeal and don't appeal, but which had to be based entirely on the parties' recollections.
So I'm sorry to interrupt. When you say there was no conveyancing file, there was no conveyancing file in evidence before the trial judge, or the parties had sought to obtain it and it no longer existed?
As I understand it, no longer existed.
It had been destroyed.
Yes.
It was
destroyed.
Yes.
I think it was assumed it had been destroyed. I think that was an assumption rather than there being evidence that it had been destroyed. But it probably would have been after 20 years.
Yes.
Which is what I think the judge said.
So,
Mr. Darton, while we're on Lady Hale, one of the things she references in paragraph 68 is the disproportionate costs
yes.
that are incurred. Would it be possible, and I address this equally to both parties, for us to have a ballpark figure for what has been spent on this litigation at each stage?
Yes, my lord. Could you again, as I would like to reply properly to your lordship's observations as regard to the execution of the document, can I respond to that?
Of course. I mean,
Okay.
we've seen an estimate of costs for today, but there obviously will have been costs at the two previous stages, and they may be very different because we understand that there is pro bono representation in this court, at least.
Indeed. Can I pick up on that point, though, to return to these policy arguments, which I say is also being referred to there, as your Lordship has highlighted, which is this. If TR1s do not have the degree of certainty, or there is not the difficulty in unpicking them that we contend for, then these types of disputes will be far more numerous. That is an inevitable consequence of the court dismissing this appeal. Of course, your Lordships will decide this case on the law, but I don't think one should escape from the implications of what it would be to say that a TR1, which doesn't bear the signatures of the transferees, is of only evidential value, if that. Because it will involve parties challenging what, on the face of the documents, most lawyers would have assumed the position to be, which is that there was joint beneficial ownership, and that that joint ownership might be disturbed, but only on some rare grounds.
Well, I mean, I don't see any of that in your notice of appeal, do I?
Well, my Lord, you do see in my notice of appeal or in my skeleton argument.
Well, I'm really interested in your grounds of appeal. You've been given permission to raise 3 grounds of appeal, 4 grounds of appeal. Partial rescission and the finding of ignorance is not a mistake. Rectification and the test in FSCH. And then the making of an order for rectification shouldn't have been made on discretionary grounds, and the application of the doctrine of common intention, constructive trusts. Right. Those are the 4 grounds that you're here to argue.
My Lord, yes.
I don't see all the policy stuff in any of that.
Well, my Lord, I do address policy in my skeleton. I hadn't thought that it was appropriate to address policy in my grounds of appeal, or that the absence of policy should be necessary to deal with that.
Okay. Well, I mean, this is a legal question, which seems to me to be quite a difficult legal question, probably even more difficult than addressed in the argument.
Well, my Lord, I of course acknowledge that this is a legal question, but one only has to read the speech of Lady Hale to see the impact that policy can have upon it.
I mean, that's a different case, isn't it, in Stack and Dowden? I mean, unless you, yeah. I mean, it doesn't affect the rectification issue.
It doesn't affect rectification, and my Lord, I'll take you to the judgment in a moment, which is why you'll see that we weren't coming here to argue a case to say that, in fact, this declaration was not binding on the parties.
No.
But what...
well, that may not be open to anybody to argue. We may just have to assume it is binding on the parties.
My Lord, I would be obviously content with such an assumption. But what I'm trying to convey is that whatever the outcome of this appeal, there will be an impact beyond the facts of its case. And the impact in terms of dismissing this appeal will be very detrimental for a number of reasons. And this court, in my submission, must be alive to those. Could I, though, please pick up yes, I've been reminded, and I don't know whether this does address it, but at page 177, this is as close. We have a copy of the respondent's statement, David, the father's statement, of paragraph 8.
Where's this? The core bundle?
This is in the core bundle, my lord, yes.
At page 177.
Page 177. I'm very grateful, my lord.
Yes, paragraph.
Paragraph 8, my lord.
Yeah.
Now, where that takes us, it's been suggested to me that suggests that the TR1s were executed at the time of certainly the father being present in the solicitor's offices. That may or may not be correct, depending on how close exchange and completion were. Again, we don't know.
It doesn't say who attended either.
No. But, my lord, that is not, I would suggest, untypical of these types of cases. If you are going to litigate over beneficial ownership of a property 20 years after it was conveyed, it is pretty likely that the conveyancing file will no longer be in existence. On any view, the parties' recollections will not have been as fresh as they would have been within a few years of that transaction. That is the quality of the evidence that a court is likely to face. It is the quality of the evidence that the trial judge in this case faced. And if the respondents are right, the extent to which what is declared on a TR1 and held at the Land Registry is valid will depend on the trial of that evidence. And moreover, there will be trials. Because those parties that might previously have thought that they would have to accept the TR1 will now be encouraged to litigate that issue. Which
Well, we haven't got any expert evidence, have we, about how TR1s are dealt with. So, you know, and I've looked to find out that information, and it's extraordinary to me that neither the trial judge nor the appeal judge actually asked the question, well, how were TR1s dealt with? What were the notes to the TR1? What would have happened had the normal practice of conveyances been followed? There's none of that. It's very hard to decide the case without knowing. You know, this document may have sat in the vendor's solicitor's office and then gone straight to the Land Registry, or you know, the difference in manuscript and typed may have mean it went to the purchaser's solicitors. We just don't know any of that. Why didn't anybody ask?
Well, my lord, I think I obviously did not attend the trial or the first appeal, but my understanding was that all reasonable inquiries were made to try and obtain the documents. This is 20 years later.
No, but just common practice. I mean,
but my lord, even if I've forgotten the name of the case, and I suspect my junior will remind me. I think there was a decision of Lord Justice Ward directing conveyancers as to how they should deal with TR1s, and I think that predates. I think that would have already have been decided and widely reported before this conveyance went through.
I mean, just cutting to the chase. In the bundle, we don't even have the notes to this TR1. And it says it's not complete without the notes, and we don't have the notes. But didn't anybody say what were the notes on a TR1 of the year 2000? I mean, surely we can find that out.
Well, my lord, we will make inquiries in regard to that. This is the material that was before the trial judge. This was the material on which he decided the case. I don't know whether the TR1 will be complete. It may be that this was all that came back from the Land Registry. It doesn't necessarily follow that because the notes should have been there, they were there. This is very much part of the reasons why we say the law should be as we contend it is.
Well, that's a non sequitur, isn't it? I mean, the law doesn't follow the law. The law is not the law because of the facts.
No, my lord, but the law does have regard to policy, as is plain in the speech of Lady Hale. Can't escape it.
Okay. Well, you've started with your floodgates argument, but it's customary to start with the legal arguments and then come to the floodgates at the end.
I shall gush no longer, my lords. Could I, however, deal with the point, because lest I forget it, could I take your lordships to the judgment of His Honour Judge Monty, Queen's Counsel?
Yes.
Because there you will see at least an authority for
This is Judge
proposition that it doesn't matter
This is
whether it
Judge-
was signed by
Judge
the
Matthews.
transferees or not.
Yes.
And
Taylor and Taylor, paragraph 21.
I'm grateful, your lordship. And as I recall the matter, it's also set out in the Gorman, which is there referred to. And we will check on that. So,
I mean, that doesn't say anything about who signed the document.
until your lordship's intervention, there was no cross appeal in this case to say that the position was different.
No, but I mean, Section 53 1B of the Law of Property Act is pretty foundational to the law of property.
It may be, and it may be that your lordship has focused in on a point that has missed other courts for the best part of 20 years.
I don't think so. I mean, certainly not. Certainly not His Honour Judge Matthews, who's a professor of conveyancing. You know.
Well, my lord, if you will grant me, I will command back with the authorities I say are with me on that point.
Okay.
But I can't address it because it was not identified, and it has been assumed in the course of this appeal that that was the position. Can I, however, say this to your lordship, that setting aside Section 53 and the trust, whatever else the transfer TR1 is, it is a contract of sale.
Is it?
Yes, my lord. It's what conveys the property. It's not a contract for sale, but it's the contract of sale.
Okay, what's the authority for that proposition? This TR1 seems to have only two parties who are both the vendors.
Well, it's the document by which the transfer is carried out. It is the contract of sale, my lord.
Well, the contract of sale is normally contained in a contract signed by both parties, notionally.
I think, my lord, a contract for sale would be signed by all parties.
Mm-hmm.
This is the contract of sale that transfers the property.
Okay.
That has always been my understanding of conveyancing practice.
Mm-hmm.
It's not the contract for sale that transfers title. It's this document that transfers this title, and it transfers this title pursuant to those terms.
Mm-hmm.
The solicitors acting for the parties in this case plainly had authority to complete on this transaction. Therefore, this was a contract made by the appellants and the respondents. Mm-hmm. It was also made with the transferors, but it must have been made by the parties who are now before you. It is the contract of sale.
Mm-hmm.
And if it is a contract of sale, then one of its terms is plainly set out at, I think, box 11, or section 11, where the box is contained.
Yeah.
And that plainly provides that the property is being transferred to the parties, for this case, and that they are receiving it as not only as joint owners in law, but also as joint owners in equity. That, my lord, I submit, has the result that from the date of its execution, the appellant and the respondent to this appeal both hold proprietary interests. They hold beneficial interests in the title to this property. As a consequence of a decision of a court, those interests may be unpicked. But, my lords, I would respectfully suggest there can be no doubt that on the date of transfer, the property is passed to appellant and respondent to hold it on trust for themselves in equal shares. And the consequence of that, my lords, is that by the judgments below, the court was not merely unpicking a contract, which I say the TR1 is, it was also depriving the appellant of a proprietary interest. Because before His Honour Judge Monty's decision, he held a beneficial interest. And if one follows through previous authorities, the TR1 could be rescinded or it could be rectified, but that did not make the transaction void ab initio. It was voidable, not void. I'm sorry, my lords, maybe I'll be able to put before you Taylor and Taylor and Wee Gorman at an earlier juncture than I thought. My junior has to hand, so we'll return to that. But can I set out my stall, my lords, because I digressed a little. But I've referred you to those three decisions, Goodman and Gallant, Stack and Dowden, Pakania and Chandragar, all of which I say are consistent with the analysis I've put before you, which is that where you have the declaration in the TR1, it stands unless it can be unpicked. And the only two routes to unpick it are rescission or rectification. And that then, my lords, brings me on to, as it were, stage two of my argument, and which I hope is uncontroversial in this court, which is that if you seek rescission, it must be of the whole of the contract. You can't have partial rescission.
Are they asking for partial rescission?
My lords, I would respectfully submit that the effect of the learned trial judge's judgment was to do just that.
Well, the effect of Mr. Justice Morris's judgment
was to convert it into a rectification, and to do so in our submission when the test as set out in FSHC was not satisfied. So our stall, my lords, I hope can be summarised in this way. Point one, the TR1 declaration stands unless it can be rescinded or rectified. Rescission has to be of the whole of the transaction. You can't just rescind a single term. That's stage two. Stage three is if you're going to rectify, which is what Mr. Justice Morris interpreted His Honour Judge Monty Queen's Counsel's judgment as amounting to, then you must satisfy the test in FSHC. That test was never satisfied on the findings of fact of the trial judge, because he made no finding that the parties shared a subjective intention. Indeed, he made findings contrary to that. And he made no finding that the parties had communicated their subjective intentions to each other which FSHC makes very clear is an essential component. And I shall take your lordship to the jurisprudence. I suspect you're too familiar with it, why that matters. And so we say where we've got to on this case is that what the trial judge did was he effectively treated the case as one as to whether or not he was satisfied that the declaration of trust did in fact reflect the party's true intentions. And having found that it didn't, he said, well, then I won't enforce it. Now that actually, my lords, is not a lot different from where the jurisprudence was being debated before Pettit and Pettit, and when one goes to Goodman and Gallant, one can see how they analyse it. In other words, what do we do with an express declaration? And we obviously contend that that was a clear error of law. It was the wrong test. The test.
And what was the clear error of law? The FSA. I mean, you've just given us your clear submissions, right? That the FSHC test was not satisfied. But then you've gone on to Pettit and Pettit and said there was another clear error of law. What's that?
Well, my lords, I'm sorry, I digressed again. I have equated, if one is interested in the history of the jurisprudential history of this, and your lordships may not be, but if you are, you will see that when the co-ownership argument first really began to get going in the 60s and the 70s, it wasn't clear what approach the courts would take to declarations of trust. And I believe there was a case called Bedson. When one reads Goodman and Gallant, one sees a summary effect of that argument, of that debate. The debate firmly came down in favour of the declaration in the TR1 being definitive. This case, this argument to say, oh, well, you can rectify in the way that Mr. Justice Morris found, is just, in my respectful submission, a rehashing of that debate. It's just going about it in a different way. And what it is certainly doing is it is coming out with the same outcome that Lady Hale described as undesirable in Stack and Dowden. So, my lords, you are of course right, I did digress, but that's the observation I wanted to make, because as I say, I think it does reflect. You can use legal terminology, and if you misuse it, you will in effect be doing exactly what in a previous incarnation the court said you shouldn't do.
Well, you may be able to argue that it is a given in this case, for good or ill, that the parties agreed that this was a valid declaration of trust, because that does seem to have been the foundation of both decisions below. And if you say that, you don't need any of Lady Hale or the history of common intention constructive trusts, simply to say that the declaration was agreed to be the declaration of trust, and a binding declaration of trust unless impugned for mistake. And that's, of course, what Pancania says, but of course in Pancania there was a valid declaration of trust.
Well, my lord, that clearly was the assumption on which this case has been argued. I mean, no doubt about that.
And there's no respondents' notice doubting it.
And there's no respondents' notice on that issue.
Okay, well, there we are then. That's the basis on which we'll
So
may have to do it.
I think
Mr. Green's got to say.
I think I had got to stage 3, which was in the way I was trying to set out my stall. Stage 4 is, of course, the question of the fact that the decision to rectify is discretionary. And there you'll have seen it in my skeleton argument. We point to the factors which we say should have militated against exercising that discretion, part of which lie in just the sheer paucity of the evidence, upon which there's already been some comment. Part of it lies in the fact that there has been such a period of time in which it has been the assumption of the appellant that he did own, that the TR1 was what his lawyers had advised him it meant. And also, my lords, I suppose within that is the consequences of the rectification. Now, I will, unless Doc take you to FSHC that looks at this and where Lord Justice Leggett deals with the matter far better than I. But the effect of rectification is to give parties a contract. It's not to undo their contract, it's to give them a new contract. And the new contract that has been given to the appellant is one in which he can't get off the mortgage. He, so far as the world's concerned, is down as a joint owner. And that has in turn interfered with his own life and his own abilities to purchase property. And my lord, stage 5 is of course concerned with how does one deal and how did the judges below deal with the question of the presumption that is plainly arising out of Stack and Dowden from the fact that legal title was in joint names and the presumption that that gives rise to.
Well, you might say that the case has a rather curious outcome as it currently stands, because it was the father's case that this property was for me and my family, of which your client is a member. But the outcome that has been achieved is one that cuts you out altogether.
It is, and these words are from a case, they're not mine. It is social engineering. It is achieving an outcome. And the basis of rectification is that the court rectifies to record not just what the parties subjectively intended, but also what they had communicated to each other, so that the defendant to the rectification knew what the claimant intended.
Yes, I'm just trying to encapsulate what I understand your case to be, which is that what's happened here is that something that the court found was not intended has been rectified into something else that the court effectively found wasn't intended.
Very much, my lord. And your lordship has identified my lay client's interest in it. But actually, if you look at it the other way round, the trial judge could have found that because of the presumption of legal titles, in fact, the son had an interest. The appellant had an interest. So it was only the combination of one, deleting box 11 declaration, and two, then rebutting the presumption, that arrives at an outcome which the father is very comfortable with, very happy with. Not what he intended, but he's very happy with it. But actually, if you take it back on those stages, as I submit you should, then the court could have just said, well, yes, we find that the TR1, the declaration wasn't intended by both of you, so therefore we remove it. We accept you had different intentions, and now we've come out to the conclusion that the son does have an interest because of the presumption.
You do have to deal with the reasoning of Mr. Justice Morris about deletion, seems to me.
I do, my lord, but before I embarked upon that, I was just hoping to just set out my stall, and forgive me if it's taken long.
And I think we've got the merits. I mean, for me, this is a legal question, and as I say, quite a difficult one. But assuming you're right, and you may well be, that the case was run below on the common acceptance that the declaration of trust is valid. As far as I'm concerned, you're pushing at an open door that a valid declaration of trust is a valid declaration of trust and has to be displaced by some legal means. And therefore you have to share us, or I think you have to share us, why Mr. Justice Morris's reasoning was wrong on the appropriate law of rectification. For my own part, I think the point about rescission is is a slight red herring, but I can see why you think you need to argue it because of the judge below.
Because of the judge below, but also, my lord, if you'll forgive me, if we would say that if the law of rectification is as Mr. Justice Morris found it to be, then there is no difference between partial rescission.
Well, I understand that point, but I mean, show us, if you would be so good as to show us specifically the passages in Mr. Justice Morris that you say are wrong. And we've all read, you know, FSCH. I'm sure we're very familiar with it, but we do need to approach this in an orthodox fashion by you explaining why the judge was wrong in words of one syllable.
Could I take your lordships then to tab 12 of the core bundle?
Is that the judgment of Mr. Justice Morris?
It is, my lord. And if we go to page 87 of that bundle...
Could you deal with paragraphs? I have it separately.
I'm sorry, paragraph 71, my lord. What the judge found.
Well, he wasn't entitled to find anything. Oh, see what the judge below found, yeah?
Yes, my lord.
Yeah. And do you say this was wrong, or do you accept that he accurately summarised what the judge below found?
I take issue with the passage in paragraph 71 beginning, as to two above, the judge did not state expressly that Tier 1 was to be rectified. And in effect, Mr. Justice Morris says, well, that is what he found.
Sorry, where are you?
This would be on page 88, my lord.
Yes, I need to know the paragraphs.
The paragraph is 71, my lord, but you have to go over the page, I'm afraid. So we go over the page to page 88 for those of us working from the pagination, but it's just above paragraph 72 for those just working off the paragraphs.
So what are you taking issue with?
Well, your lordship asked me whether I agreed with Mr. Justice Morris's summary of His Honour Judge Monty QC's...
Yeah, which bit don't you agree with?
The bit beginning as to two above.
Thank you.
I say there is nothing in Judge Monty's judgment to indicate he rectified anything. He doesn't make an order for rectification. He does make one reference to rectification, but there is nothing in his judgment to indicate that is the basis on which he made his decision.
So what's the consequence of that?
Well, the consequence of it is we should have won below, my lord, because this wasn't a rectification. It was a partial rescission, and that should have been a complete answer. If your lordships are not with me on that and say, well, no, perhaps, if you'll forgive the phrase, the judgment below could be saved by reliance on the doctrine of rectification, well, then, my lords, one needs to pass on to paragraph 72, where Mr. Justice Morris identifies two possible analyses of the trial judge's judgment. Now, option one, or analysis one, was the one argued for by the respondents. And if one passes on to paragraph 80, my lords, you will see, as I'm sure your lordships are already aware, that Mr. Justice Morris rejected that analysis.
Well, he already said it wasn't what was agreed.
Yes. And that, to pick up on a point of my Lord Jackson, it is giving the parties, what he's doing on this judgment is giving the parties that which they didn't actually intend. That's the outcome of it.
Well, that's by applying analysis 2.
he adopts analysis too, my lord. He does. And then at 2, he says that the Tier 1 should and or could be rectified by way of deletion of the declaration of trust, with the subsequent finding that in the absence of any express declaration of trust, the property was held on implied, constructive or resulting trust for the defendant beneficially alone.
I'm sorry to interrupt. Just before we move on to the judge's ground 2, can I just clarify something in my own mind? The judge rejects the variation point at paragraph 76, essentially. Mr. Justice Morris. He does it on 2 grounds. He says that on the findings of fact made by the judge, there wasn't a finding of a common intention that the property was to be held for the father alone. And then at 2, he says in any way no outward expression of accord.
Yes.
Can I just pause on the first of those, because it may be relevant if one gets to stack them down in any way. What the judge says under 1 is that it's not possible to spell out or imply from the lack of a common intention as to co-ownership in equity that there was a positive jointly held intention that the defendant was to be sole owner in equity. So if one goes back to His Honour Judge Monty's judgment, I'll keep a finger in that, but I'm going forward to tab 18 at page 162, paragraph 34 of His Honour Judge Monty's judgment. At paragraph 33, the trial judge deals with the father's intention and moves on a little bit from what was in his witness statement, because he recognises that his evidence at trial was a little confused, and he went backwards and forwards on that as to whether it was to be the family, and he was cross-examined, and surely the family means Dean. And the judge's conclusion is that his evidence was, although a little confused, he was certain that it wasn't intended that Dean would be a co-owner in equity. So, father's evidence, as the judge saw it at the end of the day, certain, no intention of any beneficial ownership on the part of Dean. Then he says, I'm entirely satisfied, having heard the evidence, that it was never intended by either Dean or David that they should be joint owners in equity. He then makes the point about Dean becoming a joint owner purely to assist with the purchase. He then says there's no discussion, and when we get to the end of the paragraph, he says this is a case where there was no agreement as to sharing the beneficial interests and no intention on either side that they would be co-owners in equity. So on the trial judge's findings, it was not Dean's intention that he should be a co-owner in equity, and it was not David's intention that Dean should be a co-owner in equity. Now, speaking for myself, and differing from what Mr. Justice Morris said in 76(1), I might be inclined to interpret that in the context of what's said in between as that each had the intention that Dean should have no beneficial ownership. Why would that be wrong?
Well, firstly, of course, I think the term is they got rid of irrefragable, didn't they? And then they settled on convincing proof. I submit that what the judge is finding there, or what your lordship is interpreting there, it is one possible construction, but it is not convincing.
Well, I'm sorry. When one's talking about convincing, one's looking at what the effect of the evidence is, and that's a matter for the trial judge. What we're concerned with is an interpretation at this stage of the findings that the trial judge made. And
of course,
so I'm just focusing on whether those are findings that, and leave aside whether there's any outward expression of accord, because that's the point at 76(2). We'll come to that. But just so far as Para 76(1) of Mr. Justice Morris's judgment is concerned, and it may be relevant if we get to Stack and Dowden. It's whether there was a finding that within their own breasts, each intended that the whole beneficial interest should be with the father.
Well, I submit that that evidence is, those findings are not sufficient to provide the convincing proof. It's no different, my lord, than simply saying that they didn't address the issue.
Thank you. All right, I took you out of your...
Yes, and what I've been reminded of, sorry, if I can take your lordship, I'm so grateful. The paragraph 34, yes, again, because above that I've had my attention drawn where His Honour Judge Monty, Queen's Counsel, says this is not a case of the parties simply being mistaken as to the consequences of their agreement. This is a case where there was no agreement as to sharing the beneficial interests.
Yeah.
Now, one could interpret that. I can see what it's... If neither of you have intended something, does that mean you've intended the opposite?
It's not entirely clear from paragraph 34 to my mind whether the judge is simply knocking down the proposition that they're equal joint owners, or knocking out the possibility of the son being an owner to any degree at all. And we return to this at the very last part of the judgment in paragraph 37, where he rejects the father's case that this was a trust for his family.
Yes.
As being too vague to result in a finding. He's there addressing the possibility that your client might have some lesser rights in the property as a result of the contribution that he made.
Yes, and I'm not suggesting that you can't read it in different ways. What I am suggesting is it's not satisfying the test, which is not surprising because there's nothing in the judgment to indicate the judge knew the test that was applicable. And it's also, if I may say, and obviously there is no appeal against the pleading point, but in fairness to the trial judge, one of the reasons why you are assisted by counterclaims seeking declarations, seeking rectification, is because you identify what it is exactly that you want to put in, which assists the judge to then apply the test.
Why do you think the judge said in paragraph 37 that he was satisfied to the necessary convincing standard?
Well, I agree, my lords, but if I might complete the sentence, that the TR1 was completed by mistake. You can be mistaken and not share the same intention. And that doesn't get you rectification.
Well, I know, but all I'm really pointing out to you is that he does seem to have had rectification in his mind, since you don't need a convincing standard to prove a mistake if you're not seeking rectification. You just need the balance of probabilities.
But a convincing standard of what, my lord? A convincing standard that you shared the common intention.
But I mean, it's not a sort of, it's not a tendentious point. It's slightly puzzling as to why the judge put it that way.
Yes, and our explanation, my lord, is that actually this is the judge approaches this matter as if the declaration is only valid if he finds that on the evidence it did in fact accord with their intentions, which we say on the law is clearly not the right approach and not the test. And that was why, forgive me, but I went back at the start to where in fact this law all began of, well, just a minute, do you look at what the parties really understood, or do you look at the document that's attributed to them? Sometimes signed, sometimes not. But the point, my lords, so far as this appeal is concerned from our side, is if you accept there has to be rectification, then I would submit it's pretty clear on the decision of FSHC that it does require the communication, which my lord you picked up on, of your subjective intentions. And you can draw, I think, a distinction there between rescission for mistake and rectification for mistake. Because rescission for mistake you don't require the communication of your respective intentions, because the consequence is you were not ad idem. So you could rescind a contract because neither party had intended it. The fact that they'd intended different things and the fact that they hadn't communicated wouldn't be an obstacle to rescission if the contract did not reflect their intentions.
I mean, I completely understand those submissions, and I'm sure they have great validity. But are we dealing here with a case where rescission was sought or granted?
My lord, this is, if you'll forgive me, my lord, I understand the inquiry. My expression of frustration is not with the inquiry, but with the fact that a proper answer can't be given as a consequence of the way the case came up.
Well, it can be given because the appeal here, I mean, whilst I quite understand that the factual findings have to be taken from the trial judge, the appeal is from Mr. Justice Morris's legal analysis. And if rescission was not argued or found for by him, and there is no respondent's notice saying Mr. Justice Morris ought to have found for rescission, even in the alternative, and there isn't, as far as I understand it, then you're pushing at an open door with rescission. It's rectification or nothing.
That is what I contend, my lord.
Yes, well, that's what, I mean, unless somebody tells me I'm wrong, and I may be, I don't see a claim that this contract should be rescinded before us. Am I wrong? Anybody else notice one? No. Mr. Green shakes his head. So
I'm grateful for that assistance, my lord. So it is at stage 3 of those 5 stages. It is rectification. And so it is the test in FSHC.
Well, that's what Lord Justice Bean told you.
And, my lord, the question then becomes, is obviously what's the test? And I don't understand there is any disagreement from the bench as to what that test requires, that it is 1, a subjective inquiry. It 2, requires the communication. And 3, when one looks at it, it is to a convincing standard, convincing proof.
Well, I suppose the question is, and this is really what led me this morning on my wild goose chase into TR1s, as to who the parties are to the agreement that you're seeking to rectify. And plainly, the actual parties to the deed that you seek to rectify are Mr. and Mrs. Shepherd. However, the TR1 represents, as you've said, a contract of sale, and represents, I suppose, on one analysis, well, it certainly represents, if it's a valid declaration of trust, which is the presumption, it represents a declaration of trust by 2 trustees, and therefore must amount to some kind of accord between them. But you're looking purely at that accord in making your argument about rectification, are you?
I submit that the only way you can unpick is by rectification. There is only one test.
Mm-hmm.
It's not altered whether you rectify by deletion or not.
Right.
And the test, we say, wasn't addressed by the trial judge.
Mm.
It was addressed, I will come to that, we say not properly by Mr. Justice Morris, because he, in my submission, appears to adopt some sort of hybrid notion with regard to deletion. But we say there aren't the findings of fact there by which rectification could be ordered.
I mean, let me be less opaque. I'm concerned that this is not a normal bilateral contract, certainly not a commercial contract, and that it could be judged by the same standards as, for example, the rectification of pension schemes and the rectification of unilateral contracts, which, as we know, are treated differently, as Lord Legate explains. And there are a series of cases, re Butlin settlement and the other cases on pension schemes, where it is perfectly clear that, for example, where the trustees of a pension scheme can unilaterally change the rules, and all they need is the approval of an employer, that you don't look for an outward expression of accord in the same way as you would in a bilateral contract. So my concern is whether you're applying the right test. And I think it's perfectly clear what the law is at this level now, although it never used to be, from FCHS. If it's a bilateral contract, if it's to be treated as a bilateral contract. My question is, which is what led me, as I say, on the wild goose chase, is it? What is it? And that led me to inquire as to what a TR1 really is and what the Declaration of Trust really is, particularly as it's signed by Mr. and Mrs. Shepherd.
Yes. Well, obviously, our response to that is this is no different in terms of contract from any other commercial contract.
Really?
So, yes, it's...
I think it's quite different.
I thought your answer would be that what is being challenged here is a declaration of trust. It's the declaration of trust in the TR1 that if you challenge a declaration of trust by a single trustee, you can rectify that simply on the basis of the subjective intention of the trustee. Where, however, you have joint trustees, then you need to have an agreement between them, i.e. an accord, in order for it to be a valid declaration. And if the declaration is not in accordance with what was a true accord, in accordance with the rectification principles, then that is an equivalent position. May not be identical, but it's an equivalent position to a contract. It's not a contract, but it's still a question of where you are rectifying a document because it does not reflect an agreement. And the contractual principles would apply for those reasons.
Yes, I'm grateful for that. But can I? I'm extremely grateful. But can I also point out, it is on one sense, it's not an arrangement, I'll use it in the neutral terms, for which the appellant provides no consideration, because you have the liability under the mortgage. That's the first observation I would make. And secondly, and I know this isn't a distinction that is being drawn in your analysis, but of course, because the TR1 conveys commercial as well as residential property, you can't, if anyone was seeking to do that, draw some distinction between the relationship of the parties.
No, but it is a declaration of trust.
It is a declaration of trust. I also contend it is a contract because it is one party is conveying and the other party is paying. And that's what's being dealt with under it.
Oh, we have to be a bit careful. It's a contract between transferor and transferee. No constat that the agreement in the joint declaration of trust is to be characterised as a contract.
That is, I suppose, well, the shepherds, the sellers, that is what they transfer to. I agree, it would have been of no practical consequence to them, but that is what they transferred to.
Well, I mean, you need to identify. I mean, this is what has troubled me throughout with this case and still troubles me. You need to identify the parties to the contract that you are trying to rectify. And obviously the shepherds were the parties that signed the instrument. But if you wanted to rectify something that they'd signed, you'd normally have to make them a party. There's authority about that. You can't rectify contracts made with people who are not there. So I suspect, you don't say that the shepherds are the parties to the contract that you wish to rectify, which comes to my lord's questions as to who are the parties and why, which is why I do think, I mean, you know, you can take your own course, it's entirely a matter for you, but I do think you need to show us authority as to the nature of the relationships created by a TR1, even if it was accepted that the TR1 created a valid declaration of trust, because the test for rectification will depend upon the nature of the relationship or the contract being rectified.
I'm grateful, my lord. I think the case which addresses certainly rectification in the absence of the sellers is, of course, the first in the bundle, which is Wilson and Wilson. And I ask you to treat that case with some caution.
So
That's
Wilson and
tab
Wilson.
one of our bundle of authorities, my lord.
Okay. 1969.
It is, my lord.
Mr. Justice Buckley, not normally a judge, treated with a great deal of caution. But anyway.
But my lord, if one looks at what was held by way of the head note, leaving your lordships to whiz through the facts, as I know you will, what if I take you to item 3 of what was held, I hope your lordships understand why I digressed at the beginning with regard to the idea that you could simply say, I say 3 there is clearly wrong. Has clearly been overtaken by subsequent authorities. Now,
Sorry, 3's been taken over by subsequent authority.
yes, because you can't simply say the evidence showed that both parties intended that in time the whole beneficial interest should be vested in the defendant. And so you can just stop it, and the deed to transfer would not have stopped a declaration to that effect. I'd say, well, it does. That's what Goodman and Galland, Stack and Dowden have firmly decided. Now, what I submit is a page, my lord, 1473, which is letters E down to H.
One 1473.
1473, my lord.
E to H, yes.
Now, what I would remind your lordships is that the date of this decision, Jocelyn and Nissen, has not, I think, been decided. So, where the judge talks about common intention, the law as it then stood was actually that it required an agreement. So Jocelyn and Nissen, as I have understood the law, pushed it on from the requirement that there should have been an antecedent contract to one of finding common intention. And
Which bit are we regarding as suspect?
well, my lords, it's E through to H.
The whole thing.
The whole thing, my lords, forgive me.
But does this tell us anything about the nature of the TR1?
No, it doesn't, my lord.
But
The nature of the TR1 as of 1969 may have been different from the one as it is now. There's been developments in relation to TR1s.
Well, there may have been, but the essential. I'm sorry, my lord. Let my lord come back in a second. But there may well have been developments in the TR1, but the TR1 for many years did contain, whatever it was called, often contained a declaration of trust. And there is authority, I think, which analyses the nature of the declaration of trust within a TR1, if only in Pancania. But you're coming to that. Sorry.
My Lord, I took your Lordships to this case simply because it addresses the question of the third party.
Yes.
Why I asked for caution in reading it is that it isn't in my submission saying effectively there's a different test for when you rectify. It's merely saying you can rectify.
Well, I was wondering whether that's the consequence of what you were reminding us about the development of the law in Jocelyn and Nissen. Because if the law of rectification in contract cases at this stage was that it was necessary to have an antecedent agreement, we don't see any of that in the reasoning of Mr. Justice Buckley in the context of rectification of a deed which contains a declaration of trust. Indeed, on the contrary, he regards it simply being a question of what the common intention was, which might suggest that contractual principles of rectification can't simply be transferred across to joint declarations of trust when one's rectifying a deed.
Well, I would contend that the case, I would not extend the authority of this case beyond the proposition that you don't have to join the vendors.
No, I understand that. But
I don't believe it supports. I'm unaware of authority that suggests a different test being applied. I was proposing
What
to take.
about pink?
Well, your Lordship took the words right out of my mouth. I was about to take your Lordship to tab 3 in Pink and Lawrence. And I think this is a case that is referred to by Mr. Justice Morritt in his judgment. As I've been informed, the TR1 in this form came in 1998, informed by my junior. So
Well, that's excellent evidence. TR1 came in 1998 in this kind of form.
that's what I'm instructed. Well, that's what I'm
While
informed.
we're on this, what is a Form TP1?
I'm being told transfer of part. That would make
Transfer of part.
TP1 is transfer of part.
Of part, but I mean, for analytical purposes, there's no difference. So that when we come to later authorities referring to TP1, the same issues may
I
arise.
don't believe so.
All right.
You can also have a declaration of trust within a TP1.
I'm grateful.
But in modern practice, you normally invite, where there is to be a declaration of trust, good practice is to fill in a JO, joint ownership form, which is signed by the joint owners, astonishingly.
Well, I'm grateful. My Lord, I'm just, I've paused at the head note and inviting you to read the passage held, because what we say about that is when we look at the head note, we'll go to obviously to the judgment, and this was Lord Justice Buckley as part of the Court of Appeal, that assuming that the declaration of trust was inserted into the transfer at the request of the purchasers, well, I note your Lordship's observations, we don't know. The plaintiff and the defendant, and that the legal estate was vested in the purchasers upon the trust declared in the transfer, the doctrine of constructive trust did not apply. So I say, well, if you look, that is really knocking out the third point that was held in the previous decision of Wilson, which was as a first instance judge, but only where there was no declaration of trust. And then going on, that a trust effectively declared could only be removed either by rescinding the document containing the declaration of trust on the ground of fraud or mistake, or by rectifying the document in the appropriate manner to vary or delete the declaration of trust. And that accordingly, in the present case, the primary burden rested on the plaintiff. So what we say there is it's noticeable. I know this is a given, but you've got to rescind the whole document. And if you're going to rectify, you've got to rectify it on the usual grounds.
Well, it doesn't quite say that. It begs that question, in fact. But let's look at the judgment. I mean, I think the problem with this is an appeal from the master, and the result is it goes back to the master to deal with it.
It did, yes, because the master ignored the declaration of trust altogether.
Yes.
I don't think it assists in providing a test.
No, I don't think it does either. But it's maybe as close as it comes. So you want to go to the passage that's cited?
Well, I think it's 101, isn't it, my lords? It's where we...
Well, I mean, it's very odd. It's true, he says, towards the bottom of the page, that if one party seeks relief against another, which can only be obtained if the document is one which can be rectified, the court may be able, as was said in Wilson, to grant relief without actually employing the machinery of rectification. As Lord Maugham said in Greer and Kettle, the doctrine of estoppel by deed will not bind the parties to it.
My lord, we've brought along a copy. I think we sent in of Greer and Kettle. Can I, if as far as it's relevant, can I address you on that? I submit that that is not a correct analysis. Greer and Kettle was about a recital of facts in what I think was a surety. So in other words, what was being decided there is that you weren't bound by the recital in the contract. So I think the effect of it was the recital said a certain set of facts were in place, which meant the guarantee, the surety would apply. In fact, they weren't in place, and so the question then was, is the party that seeks to prove the reality of the situation stopped by the declaration, or the recital, not the declaration, the recital in the agreement? I submit that's a very different situation from a contract or from a declaration of trust.
Well, but you can rely, can't you, on what he goes on to say, is in order to take that shortcut, as it were, bottom of the page and over the page, in order to do it without rectifying, for that to be the case, there must be established those circumstances which would make rectification the appropriate remedy and rectification in an appropriate form to underlie the other relief that's in fact granted. So it may be that essentially what's being said is you don't need actually have to order rectification of the document, but you do have to satisfy the ingredients of the test of rectification.
But it begs the question about what test of rectification and what is the nature of what you're rectifying.
Well, again, I'm grateful, and I had intended to finish, but it's not suggesting a different test. Can I at least advance that? The Court of Appeal remits this to the master, and what they're saying is, whether you rectify, whether you don't rectify, the test is rectification, and it is not suggesting a separate test.
Completely by that, but what I'm really concerned about is, as I keep on saying, what is the nature of the contract stroke declaration trust stroke instrument that is being rectified, because there is a different rule applicable to unilateral documents. Now, the assumption of a declaration of trust is that, well, I mean, it's not only an assumption. Trustees have to be of one mind when they make a declaration of trust. To do so validly. And that's why when you look at rectification of wills and rectification of trusts, there is a different approach by the court, which is why I'm looking for some analysis of what's being rectified. But we haven't got it yet.
Well, I'm not sure that a repetition is going to repeat, but
there may be other cases, I don't know.
Well, my lord, perhaps it's better if we, over the course of the lunch and adjournment, search to see whether there are.
But you don't know of any at the moment?
I'm not aware of a case where, in relation to TR1, this has been addressed.
And Pancania doesn't help?
I don't think Pancania does, because in Pancania, the issue in Pancania was the one which we were firmly told we were wrong on, which was Pancania says, it said, in essence, you've got to plead it. You've got to plead rectification. So much of the judgment of the Court of Appeal there is effectively saying, well, if you haven't pleaded it, that's the end of the case. And
we see in Pancania at paragraph 13, that Lord Justice Patten says, for whatever reason, the parties, both of them of full age, had executed an express declaration of trust over the property in favour of themselves as tenants in common and equal shares, and had therefore set out their respective beneficial entitlement as part of the purchase itself.
Yes, right. But that again begs a further question, my lord. It doesn't mean that it simply doesn't resolve.
No, it doesn't resolve it, but it does seem to indicate that in that case there was an express declaration of trust signed by them.
Yes, but I had not understood the case to be limited to that, and nor had I understood that's not how I have seen it analysed in the usual texts. But what I would draw your lordship's attention to, if you'll forgive me, is when you look at paragraph 12 as to the approach of His Honour Judge Harris, the trial judge, I submit it's not really very different to what happened in this case. It is in truth an objective analysis of what the parties intended.
I mean, just to be clear, my problem here is that the considerations that lead to the requirements so eloquently expressed by Lord Legate in FCHS are very different from in a commercial contract, where there is negotiation between parties, as in Daventry, which was the case that it effectively overrules, strangely, since it's
Your lordship appeared in the first instance, yes.
I didn't appear. I decided,
sorry, your lordship was the judge at first instance.
as it turns out, I decided it correctly, so Lord Legate tells us, although that wasn't the view of the Court of Appeal. So it's a matter of interest to me, obviously, but my concern is that the factors that apply to commercial contracts are different in the family situation and in the unilateral deed situation or declaration of trust situation. And when you look at cases like rebuttal in settlement, you see that very clearly. I know rebuttal in settlement is a different kind of case from this one, but the factors are different. And if this court has for the first time to say how rectification is to be applied to a declaration of trust, I mean, it's a difficult case in which to do it when the factual foundation is so slim. But if it has to, it will have to. I mean, we'll have to deal with it. But I'm just making the point to you, for sake of argument, because it's 12:10, and I imagine you've agreed to finish by lunchtime, that you, for my sake anyway, if not for my lord's, I need to be persuaded that the same factors should be, as a matter of law, applicable.
I will address that, my lord,
Yeah.
as best I can on the cases that we have. But before I do that, can I just pick up on how you draw your distinction? Because your lordship, if I've understood it properly, and forgive me if I haven't, you could draw a distinction between the nature of the parties, or you can draw a distinction between the nature of the instrument.
Yes, absolutely. Maybe both.
I would submit that if you try and draw a distinction on the basis of the parties, it's a very uncertain route to go down. That was the problem really in Lascar and Lascar, which then I think was reviewed, and some say, well, it can't be overturned, it's a Privy Council decision, but Marr and Colley. Very difficult to simply say you have a separate jurisprudence in a family context, and then you end up with the family businesses, and then you end up with the buy-to-let properties, which was Lascar and Lascar. It is a distinction which has not proved, in my submission, a very successful one in the context of the presumption in Stack and Dowden.
No, I completely understand and accept that.
So we then look at the instrument,
Mm-hmm.
and I contend that as a declaration of trust, it is both father and son that make the declaration.
Mm-hmm.
It is a contract in the sense that it transfers the land, and it transfers the land to them as beneficial joint tenants.
Well, you see, this is the problem I've got. Plainly, plainly the TR1 or registration of the land registry transfers the land to them, but that's not the relevant relationship, because that's a relationship between the purchaser and the vendor. The relevant relationship is between the two trustees. Trustees have to act with unanimity, and if you were rectifying a declaration of trust by a single trustee, right? So set law, I declare myself as trustee for you in my property at 33 Meadow Close, right? That would be a unilateral declaration of trust by the trustee and would not be rectified on the same grounds as a contract. So now you move to the situation where you have two trustees. If it was two trustees, again, you would not normally expect to rectify that declaration of trust holding their joint property on trust for you. You would not normally expect to rectify that on normal contractual terms because it's not a contract. It is a declaration of trust. Now, you would therefore expect to be not interested in what crossed the line, certainly not between the two trustees. So here, you're dealing with a declaration of trust by two people, notionally of a single mind. Whose intentions are you looking to? How do you construe the declaration of trust as a contract between Dean and David, when in any other situation it would not be? See the point?
Of course, madam. Yes. But it is, the property was transferred to them on the terms of the TR1.
Yeah.
They receive it as beneficial, as joint beneficial owners. They, as I've indicated, it is not without consideration from the appellant, because he has joint liability on the mortgage. And I submit they are taken to agree that is how they will hold it. And it is on the terms of that agreement that they also agree to pay the purchase price, for which they assume a liability, a joint and several liability to pay the purchase price. So it is not a case of a voluntary settlement. And that is why we say that it is still the FSHC test. Because you're changing what the written document said they got, because they got beneficial interests which are property interests. What the written document indicates they've accepted. I put it in neutral terms, acceptance, but of course they both had the same solicitor acting. So this contract is no question that this wasn't an effective transfer.
You mean it was an effective transfer?
It was an effective transfer. If it wasn't an effective transfer, to go back to the point taken by my Lord Jackson, we may well not have been here if we could have walked away from the transaction. It is the practical consequences that you're stuck on the mortgage, but you're told you don't own the house, and you're part of the house.
No, no, I mean, we completely understand the merits. There's merits on both sides here.
Yes. And that's why you're then, if one looks at the jurisprudence behind FSHC of saying, what is the basis for rectification? Now, I accept that within a contract, but I say extrapolate it out. What's the basis for it? It's the injustice, that's why the court intervenes, the injustice of one party holding the other party to a written contract, written terms, that they knew the other party did not intend.
I mean, let me try another tack. In a commercial contract, you negotiate the terms. In this kind of situation, families very rarely do. So all the cases we see are cases where this was simply not discussed. The dean comes onto the mortgage because otherwise they can't buy the house for the family. Nobody thinks about the consequences of buying joint property, despite the fact that if they read the Law Society's notes or, any of the textbooks on conveyancing, they would understand that this is a trap for the unwary. But it's not a situation where there is a discussion that inevitably takes place between the joint owners as to how the property will be held. And indeed, if there is no discussion, then it's held as joint tenants.
Yes.
And that is the effect of Form A, or Pro Forma A, or whatever the Land Registry call it, which they put on the register if you don't agree.
But the essence of our position is not based on the negotiations. We say the essence of why rectification is a hard test is not based on the fact of the negotiations. It's the fact that you're stuck with your written...
No, I understand that, but the point I'm exploring this for is to see whether the circumstances that have led the court to apply a different test to unilateral documentation, unilateral instruments and pension schemes and different situations should be applicable here, because that's all comes from, and you take the pension case, which is particularly it's particularly significant case. They said the trustees can change the rules with only the consent. Now you may think only the consent is equivalent to agreement of the employer, but it's not as a matter of law. And this is a different situation again, which is why I'm struggling to find authority on it, where parties, we have to look at how these contracts, how these instruments come into being in order to be able correctly to identify the law of rectification as it applies to this situation. We would be incredibly neglectful, I think, if we just assumed that the law of rectification applied in the same way to every kind of instrument. It simply doesn't.
Well, your Lordship has of course identified one class of instrument where it doesn't apply.
Well, pension schemes, wills, unilateral documentation, trust deeds.
But I submit first of all, in this relationship, they are both trustees as well as beneficiaries. So you have the distinction, as it were, that it is not unilateral. So in the example your Lordship gave this was a dispute between trustees and beneficiaries. No, this would be the respondent does not have the power to act unilaterally. That's the difference, if you like, in the terms of the instrument.
But to develop my Lord's point a little in the contractual analogy, if you did have a situation in which the parties were in a negotiation as to what beneficial interest to take, the solicitor would have a conflict of interest in acting for both of them, unless he got the informed consent of both. If it were a contractual analysis, which rather illustrates that the practice is not to get informed consent. I don't suppose a conveyancing solicitor ever gets informed consent to act for both of them on that basis, on the basis there might be a conflict of interest between them, which again rather suggests that one's not looking at a contractual analysis. We're looking at a rather different situation.
Well,
From something that's analogous to a contract.
If I can give my own personal evidence, my daughter and her partner, they very much were in a negotiation in which I had some input. So it is not unheard of.
No, it's not unheard of, but certainly not the norm. And the conveyancing solicitor will normally simply take instructions from each of the joint tenants and give them no advice at all, really, as to that being a matter on which they may have a conflict of interest and they may wish to take separate advice and they may need to instruct their own solicitors.
My lord, that could arise, but then, as Lady Hale observed in Stack and Dowden, in the vast majority of cases, and I am only speculating, it's dictated by the building society. Because it's in the interest of the lender to treat both as joint beneficial owners.
Well, that's true, but perhaps not particularly helpful.
Well, I think what I is...
I mean, what I would find helpful is to look at the discussion in the cases that are different from the normal commercial contracts. I mean, my lord and I certainly, I'm excluding my lord, Lord Justice Jackson, may not be quite as familiar with these authorities, but we are really very familiar with the authorities on commercial contract rectification. But the question here may be the one I've posed to you, and you may need to look at those that have a different approach, as Lord Leggatt does in the passages of his judgment you've drawn attention to in your skeleton, when he comes to deal with pension schemes, and he explains why they're different. I think it's a weak part, if I may respectfully say so, of his judgment, because it doesn't really say why, when there has to be consent between two parties to the pension scheme, rectification should be different. But anyway, he assumes it is. But are there other cases that give us insight?
I don't know whether this will be helpful or not. I mean, it seems to me that Stack and Dowden contains a passage which, from page 103 in the electronic bundle, paragraph 49 in the report, there are 3 or 4 paragraphs there that survey the history of declarations in the context of purchase of land, ending with the TR1, paragraph 52.
Well, it tells us it's a problem that only has arisen since 1998.
But speaking for myself, I would be surprised if there aren't some cases, although this is not an area with which I'm hugely familiar, involving declarations of trust by joint trustees whom it is later asserted did not agree on the declaration. And I think for my part I might be helped by a reference to the bases on which one can challenge the declaration of trust on those grounds.
They are few, and I don't think I obviously take the point on board, but I mean, preparing for this, we may have missed the obvious, even the blindingly obvious, but I'm not aware of cases where this has actually been considered.
The problem is that trustees have to act unanimously. And as my lord points out, solicitors couldn't act for them if they were not unanimous, if they knew they weren't unanimous. So it's a dispute or a lack of unanimity that lies below the surface. But I still find, I mean, Stack and Dowden is important, as my lord points out, and does explain that this is not a completely new problem, but it doesn't look at it from the point of view of rectification, which is what we're looking at it from.
I think that apart from Wilson and Wilson, I'm not aware of a case where rectification has in fact been ordered. I mean,
Well, there'll be lots of cases. I mean, rectification is meat and drink down in the master's corridor in the Chancery Division.
Outside, we're talking outside the conveyancing.
Yes, so
context.
the effect of the TR1 has been, and there's been recent articles, I think it was Bevan wrote an article that the challenge that's been to the declarations has actually been to latch on to the subsequent conduct. And the sort of Clark and Midas, and to say, well, okay, so that declaration stuck at that point, but things have moved on now, so now we can argue because of this. But it so far as my reading around has been, it's been taken as a given that the TR1...
Your junior's got Snell out, which is an excellent place to get, an excellent thing to get out.
What does this... My lord, it may be an excellent point, and no reason to doubt it, but I'm not going to address you on without considering that. But
which passage was he looking at?
Well, this it's worse than that, my lord. I tell you why. Because my learned friends sent in to you Snell's because it was referred to by His Honour Judge Monty QC. That was the previous edition. So what I'm actually holding is the old version of Snell, which is why I paused before I...
Well, it won't be very different to the new one.
My lord, one would hope not. But can I say also this, just to pick up, and I appreciate it is not even coming close to a part of an answer to the excellent inquiry made, but there is another aspect to the effect of the TR1, which is that it definitely gives the parties proprietary interests, gives them beneficial interests. So if I could draw a distinction, and I appreciate that I'm not backing this up by legal authority at this juncture, my lords, but if I could draw a distinction, in this instance, the parties have received a half beneficial share. And this is where I endeavoured to set out my stall this morning, that by the orders below, what the appellant definitely had, as at the date of the conveyance back in 2000, he's now told he doesn't have. So to go to your analysis on the pensions, this is not a case of whether I get a future benefit, this is, can I claw back that which I've already given you? So there are potentially, my lords, three grounds, approaches to saying the TR1 stands in almost all cases. One is the contractual approach. You've heard me on that, you're familiar with that. The second is the question of the trust. But the third is it does convey the property. So you're not altering my contractual rights, you're altering what I already hold. And, my lords, that may in part explain the clear reluctance, as expressed by Lady Hale in Stack and Dowden, to start unravelling the declaration that is contained in the TR1. Because there clearly is a reluctance. And that reluctance in the passages that I took you from is not based on the fact that that is what the parties intended. It actually recognises in a lot of situations they will not understand.
So, I mean, in Butlin's settlement, it was a voluntary settlement to allow a majority of trustees to exercise a power under the settlement, but in error the settlement didn't give effect to that intention, and the court rectified it, even though only one of the original trustees knew of that intention.
But if I could go back, my lord, I mean, if your lordship will allow me just a short response to deal with this at a later juncture in today's hearing.
Well, of course, you'll come back and reply anyway.
I'm grateful. But could I
mean, you may find it more useful to let Mr. Green go now and then come back and reply.
I will. Could I, lest I forget, and I'll no doubt regret it, but could I just say this, to draw on the case you've just referred to? Here, it is not a question of a settlement in the same way as it would be in the classic situation of tax planning, because as I've indicated, the interests have passed. Subject to a very limited extent, the court, the trustees cannot change the interests that they hold. They each hold half. That's what they got. This would be equivalent to the settlement where there has been monies paid out. And so I think that places it on a different footing. Now, I note your lordship's observation on the time. I will whiz through just those stage 4 and 5. Obviously, into stage 4, we do say that there seems to have been... what I should just say in relation to the judgment of Mr. Justice Morris, that's paragraphs 70 into 80, is that if the test is FSHC, it can't work because there is no communication. And as I've indicated, whether you delete a term or whether you rewrite a term, it's the same. Now, I appreciate your lordship's observations that maybe out there is a different test. We say not, but I say if that is the right test, which Mr. Justice Morris understood he was applying, then the paragraph 70 to 80 of this judgment can't work because there wasn't a communication. I would say, and this was the point that we've had in discussion, did they share a subjective intention? No, they didn't. But they never discussed it. And there's reference to try and make a tacit. It suggested, well, you can have a tacit agreement. If you look at the examples giving a tacit agreement, yes, if you have a conversation, some things remain unsaid but are nevertheless communicated. But here, there's no communication at all. And the other circumstances where you have a tacit position is where there is a practice or custom. And here, of course, we say, well, there is no practice or custom. In fact, the reverse. What Lady Hale established in Stack and Dowden was the assumption is that the legal interest follows the beneficial.
The other way around.
You're quite right, my lord. Perhaps it's time I sat down. But before I do, stage 4, obviously there is a discretion, and you have our points on that. This is an utterly unsatisfactory case. If one steps back from it, I can't help feeling that there would have been a lot to be said for have never gone down this route at all. You don't have the information. And that is because of the passage of time. And tied in with that is the fact that for the best part of 2 decades, the appellant assumed and was entitled to assume he was a joint owner. And he took the financial consequences of that in terms of his mortgage liabilities, his ability to get a mortgage, his treatment in terms of his wealth. He was treated as if he did.
Where do we best find your client's exposition of his position on the sort of merits? In his statement?
In his statement, and it's not great, my lord, but
it's not great.
Sorry, you'll forgive me, I slipped into the practitioner, and I'm very conscious of the context of witness statements.
It is what it is, right?
In fairness to those, my lords, if one stops for a moment, when this trial started in Central London County Court, there was no pleaded claim for rectification. There had been 3 previous judges, including His Honour Judge Monty, Queen's Counsel, saying, you need to sort this out. Therefore, the witness statements did not address, in anything like the degree they would have done, those points. But those points do arise, and it's not the case that rectification is automatic, as seems to be assumed in the judgments below. It's like, well, if we... then we
So has there been a mediation in this case? I mean, just as a matter of interest?
I don't believe there has, my lord. Could you grab me a moment on that?
Yeah, I saw that.
Yes, there wasn't, my lord. What I'm reminded of, and I'm not seeking to sort of, we're beyond that point of, you know, a tit for tat, but in His Honour Judge Monty in costs, he did make observations on the lack of mediation in relation to costs. If you go to his order, they're just stuck behind it. So I think tab 10.
What, the reasons?
Is it not? Is it not? Is it Morris? It's Monty. I thought there was something on supplemental bundle, tab 1. Sorry, supplemental tab bundle, my lords, tab 1. And yes, it's reasons for refusing permission. Yes, so page 2. And I hope your lordships will find there that, in effect, there was no order for costs. Part of the reason was the absence of pleadings, but part of the reason was defendants' failures combined with other procedural matters, and in particular the refusal to mediate, led me to make certain cost orders. So I'm not... As I say, I think we've gone beyond the point of exchanging blame on the who didn't mediate and what. But could I just say this, and I note the time, my lords, and I really will sit down, but can I say this? These cases can become extremely difficult to mediate because there is so little room for manoeuvre. When one looks at the policy reasons of all this, the appellant acted on an assumption that I say he was perfectly entitled to assume, which was that there was a TR1 and there was no claim for rectification. The defendant took a different view. We've now got to this stage, and this is a paradigm of example of the sum total of human misery that can be wreaked by not sticking to TR1.
I'm not sure why you say it's a side wind only. There's so little room to manoeuvre. I mean, if there's room to litigate, there's room to manoeuvre. So I don't quite understand why these disputes should be particularly difficult. One might think that from an objective point of view, it might be fairly easy to pluck a solution if the parties wish to do so.
It's a proper inquiry, my lord. I think the answer may lie in again the way Lady Hale said in Stack and Dowden, how people's recollections and reinterpret the past. You have a property whereby the consequence of my client's name being on it is he and his family can't purchase.
Yes, I understand that.
If it's sold,
the parties' positions have been all or nothing. Whereas the whole point of mediation is that there's very often a third way.
As a lifelong Liberal, my lord, I would always agree with that. But the point is that we did not set our face against that. And
I wasn't entering into a discussion about who was right or wrong about it, but I just didn't see that this sort of dispute was particularly impervious to mediation. I would have thought, on the contrary, it was exactly the sort of dispute for which mediation was invented, and for which litigation, particularly through 3 levels of court, is entirely unsuitable.
I of course concur, my lord. I'm saying that it needs to be settled at an early stage. That's when the problems come in. It cries out to be settled at an early stage. Finally, my lord, I do make the point, and I won't trouble you because it's in relation to where we got to as a result of rectifying or deleting the declaration of trust, is we then went into a situation of the presumption was with us. So we contend we should still have won. And what we rely on there is that, in particular, we assumed a joint liability on the mortgage in circumstances in which the lender certainly required us. We did expose ourselves to that liability. And at the date we did it, there was a very real chance we might have been called upon to pay it. There was a complete lack of clarity between the parties as to what was to happen on the beneficial interest. And what the judge didn't find in this case is an express agreement that the mortgage was always to be paid by father. So I draw a distinction there.
No, but you did find he did pay it.
Yes, he did, my lord. But that,
and he found your client was not telling the truth about that.
My lord, yes. But the ownership of the property determined at the date of purchase before that occurred.
No, I mean, you're pushing it an open door. Of course, your client nationally took on a potential liability.
We say that effect was enough to stop the court departing from the presumption. And particularly when you remember, Lady Hale, about do the parties always understand? No, of course they don't. Does that mean the presumption doesn't necessarily apply? No, it doesn't. And obviously, my lords, in relation to the mortgage payments that have been made, there is a mechanism for relief with regard to that by way of an equitable account.
Could I pick up the point that I was asking about a moment ago and look with you at the supplementary bundle at page 79, page 80 in the electronic version. Where one sees that on the 4th of March 2019, the matter was given directions by Deputy District Judge Cahoon, who recommended mediation in bold.
But
I'm not making this point to you as opposed to Mr. Green. I'm just pointing out that at least at that stage of proceedings, the court was well alive and gave the parties all the information that they needed in order to pursue a mediated settlement, had they both wanted to do so.
as I say, I would emphasise we did not turn our face against mediation, and you've seen that His Honour Judge Monty QC's finding that.
No, I'm really coming back on it because I didn't, again, want what you said about these cases being very difficult to mediate. As it were, getting into the water flow.
I would like to qualify that by these cases need to be settled and mediated quickly before the costs get out of control. I would also, before sitting down, subject to dealing with those further points in reply, also add the greater that the law can give guidance to the parties as to what the outcome of the litigation is, the greater the chances of settlement should be. So, my lords, subject to replying to dealing with those additional points, which I apologise for not being able to deal with them expressly now, that's the case for the appellant.
Okay. Anything else?
No, thank you.
Thank you very much. Mr. Green.
My Lord, I have prepared a very short speaking note
Okay.
in the hope of making sure that I remember all the points I meant to make. and providing your lordships with all the
Can it
references.
come electronically over the agenda, please?
My junior will make sure that that is done. My lord, I start with a number of propositions.
Are you going to hand it in?
Oh, forgive me, my lord, I wasn't sure if we were allowed or permitted to hand up documents, given the restrictions.
Well, I think we'll live with handing up of documents. My concern is that I should have it electronically.
My lord, I preface my submissions with recognising first that the respondent has assumed that the formed TR1 Declaration of Trust in it was a valid declaration of trust. That is an assumption that was made following the finding by His Honour Judge Monty QC that it was valid, notwithstanding it wasn't signed.
So that's not open for discussion here.
My lord, no. And just for the note, it's page 160, paragraph 18 of His Honour Judge Monty's judgment, where he refers to the authority, I think, of Taylor and Taylor, and says it makes
Well,
no
this is
difference.
dealt with in quite some detail. We don't have it yet, but...
My lord, no. We don't have it yet, but in reliance on that authority, His Honour Judge Monty indicated that it mattered not that it wasn't signed by parties. And the other point to make clear is that we have not approached this case on the basis that the test in FSHC does not apply. Otherwise, we're not suggesting that there is a different test for rectification of the Declaration of Trust. That hasn't been our case to date. Of course, that was before the illuminating discussion this morning, where we may be put on inquiries over the short adjournment, and we may find things that cause us to take a different view. But thus far, we have sought to address the case on the basis that FSHC applies to this situation. Well, what I set out in relation to ground 4, the principal ground on rectification and outward expression of accord, a number of propositions. The first is that where a contract contains the term that neither party intended to be included in the contract, the court may rectify the contract by simply deleting the term. Well, I take that from the case of Wilson and Wilson. I'm conscious that your lordships have already seen these authorities in the passages referred to, but would it help if I took your lordships to it again?
So, where are you, Wilson and Pink?
Wilson and Wilson first.
We really don't need to go to Wilson and Pink. We've looked at them ad nauseam. We didn't get as much help as we'd have liked.
Well, both cases indicate that one can simply delete a term.
Well, I mean, in theory you can delete a term, but what's the difference between deleting a term and rectifying it to say something different?
Well, it depends on the context.
Well, what's happened in this case, as I understand it, is that Mr. Justice Morris proceeded by stages. That he felt he was able to delete but not to vary. So he deleted and then he varied, as it were.
The result may be the same, but actually he approached it in stages, your lordship has said. He deleted the term. That meant that there was no declaration of trust. It was then up to the court to decide on what basis was the equitable interest held, and then he applied a
But how can there be a continuing common attention that there should be nothing said on the TR1 if they didn't discuss it?
My lord, when it comes to the common intention constructive trust, the court looks for an objective.
No, I'm not talking about constructive trust. I'm talking about rectification. In order to rectify a contract, a commercial contract, you have to have a continuing common intention at the time you execute the contract as to what it should say.
Well, yes, that brings me to my second proposition.
Right.
The first proposition was simply that one can delete a term by way of rectification. The second is this, that the requirement that there be...
Sorry to slow you down, but I wonder whether there's a conflation, which may be rather important in your first proposition, between neither party intending something to be included and the parties intending nothing to be included. And I wonder whether if you're simply deleting a term, as the judge did, on the basis that neither party intended it to be included, I wonder whether that is a conflation, which is treating rectification as the default position rather than something that has to be established by convincing proof. If you don't discuss it and it goes in, then the mere absence of an intention that it should go in may not be enough for rectification. What you may need is a positive agreement, which you may have in some cases,
Yeah.
that the contract should remain silent on it.
Well, in my submission, that's not as far as the authorities go. FSHC was a case where a number of obligations, onerous obligations, as your lordships are well aware, were simply deleted because they went beyond what the parties agreed should be included in the contract.
Yes, but I mean, my lord's point is a good one, because here there was no evidence that both parties intended nothing to be included. Both parties did not address their minds to it at all.
My lord, that's, with respect, that's fair enough, but there were findings that all the son was intended to do was to assist the father in getting first the mortgage and then the property, and that is all he was doing. If I can take your lordships to the judgment of His Honour Judge Monty.
But I mean, the finding that the son only intended to help the father get the mortgage is not really to the point as regards rectification. It is very much to the point as regards the common purpose constructive trust.
Well, in my respectful submission, it also goes to the point of rectification.
Mm-hmm.
If one looks at paragraph 3
Yeah.
of the judgment, one can see that here His Honour Judge Monty is setting out facts that are not disputed, they're background facts. And one of the facts was that, it's a few lines down, David could not obtain a mortgage advance, which he needed to buy the property on his income, and he asked Dean to help out, as Dean was working and earning. He goes on to say the property was then bought in October 2000. So there was a request for help there. And we know at paragraph 34 of the judgment, His Honour Judge Monty goes on to say, I'm entirely satisfied having heard the evidence that it was never intended by either Dean or David that they should be joint owners in equity. In my judgment, the position was this: Dean became a joint owner purely to assist with the purchase, so that the mortgage advance could be obtained. In my submission, the sum total of what was agreed was that the son should help the father get the mortgage and then the property by lending his name to the mortgage and the transfer, and that was it. That was the extent of what was agreed.
Well, how does that translate into deleting a declaration of trust?
Because, my lord, the declaration of trust in this case was contrary to that agreement between the parties. The declaration of trust actually conferred on the son a half share of the property. That wasn't what the son agreed to do. The son was simply there to help his father by lending his name, as I say, to the mortgage and then to the transfer.
But you don't get rectification simply on the grounds that a contract contains something which wasn't the subject matter of prior agreement. Those aren't the principles on which one applies rectification. So it's not sufficient to say there was something in this document. I won't say contract for the moment, but if one's applying contractual principles, there's something in this document which reflected something which hadn't been agreed and which neither party intended. You've got to go further, haven't you, for deletion, and say there was a common intention communicated between the two that the document should not include this.
Well, FSHC is a case where there was a common intention that the document should go thus far and no further. There was no discussion at all in FSHC of the additional obligations that proved to be objectionable. Indeed, the point was made in FSHC that the fact that there was no discussion about those particular terms was telling, because if the parties were going to include them, one would have expected very extensive discussions and negotiations about those terms. Perhaps I ought to turn
So
to
the inference in FSHC is that there was an agreement that they should not be in the contract, as my lord has put to you in relation to this.
Well, there was no consideration of the terms in question up to the time the contract in FSHC...
Well, show us the relevant passage.
Tab 15, my lord. And in my note at paragraph 2, I have gathered together what I hope are helpful and relevant passages on this point. At paragraph 4, Lord Justice Legate, as he then was, set out the, or summarised the facts of the case as decided by the trial judge. If I could invite your lordships to read that. And then, my lord, it's paragraphs 42 to 44 that set out in more detail the findings of the judge below on the issue of intention.
I'm so sorry, which paragraph?
42 to 44, my lord.
Thank you.
There was a common agreement found that the document should satisfy the parents' obligations to grant security and do no more.
My lord, yes, the point being that there was no discussion, no consideration at all of the additional obligations that found their way into the contract.
No, there's no, that isn't part of the finding. The judge found as a fact, paragraph 42, their subjective intention was to do no more than provide the third party's security. So far as the intention was concerned, it was the intention that the document should not contain something. That's what I was putting.
My lord, that's one way of interpreting it with respect. If one goes, for example, to paragraph 182, one can see that there was simply no consideration at all given by the parties of the objectionable terms.
Which paragraph do you want to go to?
182, my lord.
182. there we are. He says, rather than the judge's factual findings, their common intention was the legally specific one of binding the parent to particular contract terms, but not to other specific terms contained in the same document.
Well, yes, the contract was to go thus far and no further. But there was no question of the parties having actually considered those additional obligations and said to each other they must not go in the contract. It was simply that our contract is only for X, it's not for X and Y.
Well, we haven't got the underlying evidence, but one imagines it was something along the lines of this is all we want to achieve.
Well,
that would be essentially what is reflected in these findings.
well, there was some argument about that. If one looks at paragraph 184, I see the time, but at paragraph 184, counsel for the appellant was seeking to make the point that although there had been communication between the parties, they did not say in express terms that the agreement was to go no further.
Well, shall we come back to that? 2 o'clock. Mr. Green, thank you.